And thank you very much for joining us here on PM Express. A conversation about the verdict at the Supreme Court today and its implications. As you've been told by those who follow this, it has far-reaching implications for the way we run our democracy. And that's what we're going to be looking at today. It has to do with the Special Prosecutor's Office, Martin Amidu to be very specific, but beyond him, it has fundamental implications for us as a people. Let's go into what happened. We know that the Supreme Court, in a majority decision, which is a 5-2 decision today, ruled that Martin Amidu is eligible to hold office as Special Prosecutor. What's the background to this? Why do they say this? It means the retirement age, and which is a very important bone of contention here for employees of the public service, does not apply to the office of the Special Prosecutor. In fact, that is a position that the Attorney General argued forcefully in this case that has traveled for several months since his office was set up. Now, the former Deputy Attorney General, who's going to be my guest tonight, Dr. Dominic Ayine, he took this case to court, and his argument was a very simple one, that if you look at the Constitution, if you are in the public service and a public officer, you are mandatorily required to retire at the age of 60. In fact, you could be on and stay on for an additional 5 more years, of course, if the executive decides to, by contract, extend it. But you cannot go beyond 65 years. He argues that at the time that Martin Amidu was appointed, he was 66 years old. And if he cites the article 1901 in the Constitution, which says, quote, the public services of Ghana shall include, of course, the offices as set up and prescribed by Parliament. And he argued that the office of the Special Prosecutor came under that broad part of the Constitution under the public services. Well, it appears that the Supreme Court did not agree with him. And he emphasized the point about Martin Amidu's age at the time that he was appointed by the president to occupy that particular position. And he says that, again, is an infringement and a contravention of the Constitution Section 13(3), also of the Office of the Special Prosecutor Act 2018, 959. Now, the Attorney General's office did something quite brilliant in terms of legal maneuvering. Something that we all have taken for granted in terms of what the Constitution has said about retirement age. They said it was not as simplistic as Dr. Dominic Ayine had posited in his argument before the court. And that, I mean, the fact that Martin Amidu has been appointed as the head of the Special Prosecutor's Office doesn't necessarily make that office one under the general heading of the public service, because that is a specialized agency. And they create a distinction, very fascinating distinction between a public officer and a public office. We'll go into that very shortly because the implications are really far-reaching, and that's the Attorney General's arguments there. Now, the AG's office made this argument quite forcefully. I mean, just to simplify, that a specialized agency, that's what the SP, the Special Prosecutor's Office, is, and cannot be treated like other public offices. It appears that the Supreme Court agrees with that position. A very important point to note tonight is that the Supreme Court hasn't given the detailed reason for the decision it reached today. We expect that to be available tomorrow, but even ahead of reading its reasons, the mere decision that they've taken, 5-2, has on the surface some interesting implications. Already we are hearing from Dominic Ayine that he doesn't intend to go for judicial review because of the high bar required for that to happen. And so we'll look at it and its implications. You want to stay with us for this conversation. After the break, my guest will join me, and trust me, it's going to be a very interesting conversation and a lot to learn from it as well, and its implications. Stay with us. And thank you for joining us here on PM Express. My guest on this show tonight is a former Deputy Attorney General, Dr. Dominic Ayine. Also joining me is the Vitus Azim. He is a former head of the Ghana Integrity Initiative and an anti-corruption campaigner. Joins us also via Zoom. We'll be joined also by the current Deputy Attorney General, Joseph Benka Diop, will join us. Of course, we had hoped to speak to Kwikwaza, Prof. himself, but he's written an article about this, quite interesting article. We'll be sharing some of the portions with you. I'm grateful, gentlemen, for your time here on PM Express. Let me begin with you, Dr. Ayine. You took this matter to court today. Tell me, having reflected for a few hours now since this judgment, what's your reaction?
Thank you very much, Evans, for having me. I think I was initially disappointed, very much disappointed, because I firmly believed in the position of the law that I took to court, and I still haven't departed, from that position. Maybe I will be convinced by the reasons given by the court when I've had the opportunity to read the reasons that they have, provided, and also the analysis of the law that they would have espoused in their judgments, and then I would decide whether or not I am really convinced, about the decision of the court today. But as I would say, I'm very disappointed in the outcome. But of course, this is a country governed by a constitution, and the constitution is very clear that the Supreme Court is the ultimate arbiter of constitutional disputes, and also that, the Supreme Court is the only court that can interpret and enforce the constitution. And I think fidelity to the constitution, to me, is paramount in any constitutional democracy. So for me, we have to abide by that decision, because that is the law.
If you don't mind helping us again, just a summary of what was the gravamen of your case at the Supreme Court against the SP?
Right. You remember that when the special prosecutor was nominated by the Attorney General, the nomination was forwarded by, letter to the Speaker of Parliament. And because the OSP Act itself provided that Parliament must vet and approve his, nomination for appointment by the President, his CV was transmitted to the Appointments Committee of Parliament. And the minority chief whip, the Honorable Muntaka Mubarak, sought my advice with respect to what are the legal issues to be posed to the special prosecutor. And in the process of, looking at the documents that were submitted, I looked at his CV, and the first thing I realized was that he was at the time 66 years of age. And then I told the Honorable Muntaka, I said, there is a potential constitutional problem here. He said, what is it? I said, well, under the Constitution, the maximum age of retirement, if you add the post-retirement contract of 5 years, is 65. The special prosecutor, or the person nominated for appointment as a special prosecutor, is 66 years of age. And so, by my, my reasoning at the time, and as I said, I will wait to see what the court will say. I took the view that being above the age of 65 years, he could not be employed in an office created within the constitutional framework for the public services of Ghana. Because remember that when Parliament was enacting the law, it made it abundantly clear that this was an Article 191D public office. And even for the education of your listeners, or your viewers, Article 191 lists all the public services, properly, so-called in Ghana. All right, so it creates the public services of Ghana, and it lists them numerically. Okay. And then goes on to say that Parliament may create such other public services, okay, as Parliament, in its discretion will, prescribe. And so when Parliament enacted the OSP Act and created the Office of the Special Prosecutor, basically what Parliament was doing was exercising a power pursuant to the chapter of the Constitution dealing with the public services of Ghana, and specifically the residual power granted Parliament to create public service offices, under Article 191D of the Constitution. And so that is the context within which, the issue of his eligibility, with respect to age, was raised by myself and taken to the Supreme Court.
But very interesting there, and I guess there were fundamental, far-reaching implications you saw if he was allowed to pass at that age. That could have a ripple effect on the way we had understood the Constitution when it comes to retirement age over the years. Now, in the wake of this judgment, that fundamentally has changed, has it not? So that going forward, it means, and correct me if I'm wrong, any president can appoint anybody regardless of the retirement age, 66 all the way to 100 or beyond. What is that? What it is?
Well, subject to reviewing the reasons proffered by the learned justices of the Supreme Court on this matter, I think that is the broad general implication of what the court has said today, in the sense that if we allow Parliament to create offices and then to confer retirement ages on the officers of those public offices created by Parliament that are over and above what is stipulated by the Constitution, then it means that any president can can engineer the creation of a public office, located within the chapter on the public services of Ghana, and then give them enhanced retirement ages, different from what applies, generally in the public services. All right, and contrary to what would be the legitimate expectation of other workers in the public service. So for instance, I don't think that the Public Services Commission will be really very happy with this decision, because I do know that as a matter of, public policy, they've been struggling to deal with these issues of people being, on retirement and coming back on post-retirement contracts and taking, positions within the public service. So I think that it has far-reaching implications for the way we run our public services.
Hold on for me there, because there's more I want to explore about the implications of this, even as you wait for the specific reasoning behind it. I want to bring in Vitus. Vitus, what was your immediate reaction when you heard the verdict?
My immediate reaction, I think that we should not be looking at just Magnamido. It is not Magnamido, it is the position, although this case was involving Magnamido. The point is that there are already several people, a number of people who are already occupying those certain public service positions who are above 65. And so, like you said, the far-reaching implications. This ruling means that those who have been occupying those positions illegally since 2017 are now being told that, yeah, you are okay, you are occupying the position. The president has not contravened the Constitution, which I don't agree with. I am not a lawyer, but I think that the Constitution is very clear. 62, 2, and 1, 65. Unless the special prosecutor was appointed as an appeals court, maybe at the level of the appeals court judge who can go on retirement at 65 or so. I've looked at the law. There's no exemption in the Office of Special Prosecutor Act that says that the special prosecutor can be above 65 years old. I have not seen that. So I do not understand the basis for that decision. although, like you said, maybe there are reasons, but I haven't seen any exemption for that position. And based on that, I think that even though when Namido was appointed, civil society, especially anti-corruption, were happy about it, it is not to do with the individual. It is to do with the law. And he said that the Supreme Court is the final arbiter. But I don't think that the Supreme Court has the right to amend the Constitution. So from my view, I think that there is a problem with the decision, unless they explain tomorrow that it's a bit different. I mean, maybe there are other reasons that as a layman, I don't understand. I mean, and let me say that I have written about this on my Facebook page a number of times before, in 2016, 2017, about people that are above 65 and are occupying certain positions. And sometime I think in 2018, a list of these people came out and said they were going to be asked to go. Then the Minister of Information came out to deny that it was not true. And those people have remained in their positions up to date. So it is even more to do, it's even more a political issue than just the Office of Special Prosecutor. And that is worrying. And you believe that, and you believe the Supreme Court has now endorsed that particular position of the political position that you expressed? Yes, that's what I think. The Supreme Court has endorsed it. So you can no longer say that maybe the Executive Director of Forest Commission should not be there. You cannot say that somebody else should not be in that position, even if the person is 70. And I don't know whether that is okay for our present democratic dispensation. Very, very interesting perspective. Thankfully, we've just been joined by the current Deputy Attorney General, Joseph Diop. Mr. Diop, thank you for your time here on PM Express.
Thank you very much, my brother. Thank you to your viewers, and thanks for having me.
Yes. So tell me, what's your reaction to the Supreme Court verdict today?
Thank you very much once more. First of all, I have listened carefully to the learned former Deputy Attorney General, the Honorable Dominic Ayine, and I've also just listened to your second...
Vitus is in.
Yes, Vitus. And I want to say categorically that even before this verdict, I've had private discussions with my colleague lawyer, the Honorable Dominic Ayine, and he explained his position, and I equally explained our position as an Attorney General's department. We've had those chats privately, even long before this time, because as lawyers, that is how we expand the frontiers of law. Now, the second speaker, Mr. Azim's argument, I have a very, very big problem with that, because the court did not make a general and categorical statement that 65 years retirement is applicable to all above 65 years you can work in the public sector and etc. That is not what the court said. The court made a distinction between what the Honorable Dominic Ayine was asking for and the Office of the Special Prosecutor. There was a clear distinction made by the court, and that was the argument.
What was the distinction? What was the distinction?
Thank you very much. What the court said was that the Office of the Special Prosecutor is a specialized agency, not in the contemplation of 1901 as espoused by the Honorable Ayine. And that has been our position all along. We have argued that that particular position, and even in your intro, you indicated it, we try to draw a distinction between public officer and public office. And we said that the Office of a Special Prosecutor is a special purpose vehicle. It is not one that is contemplated by the said Article 190 as you have actually enumerated earlier. And the justices of the Supreme Court agreed with that distinction that we drew their attention to, and so held. But they did not in any way endorse that all other public officers, even if they are above 65, should continue to hold office. They haven't said so. And we should not read anything into the judgment apart from what the justice said, the learned justices of the Supreme Court did say today. You see, I indicated that, look, the Supreme Court is the sole court in our jurisprudence responsible for constitutional interpretation and interpretation of any statute if there is any conflict. Now, our position is this, that you have the Office of the Special Prosecutor, which has been crafted by Parliament as a specialized agency to handle corruption and corruption-related offences. Now, Parliament passed this act, and then the Attorney General nominated, or forwarded the name to His Excellency the President, and was nominated for consideration by Parliament, and then Parliament did confirm. Now, our argument has been very simple, and we urged on the court that the court should draw a distinction between public office simpliciter, as argued by the learned former Deputy Attorney General, and public office with relation to the Office of Special Prosecutor, which is a special vehicle or special purpose vehicle meant to fight corruption. And we said that that office is not contemplated by the said Article 190. And the justices agreed with us. They did not give an omnibus ruling that all other public officers can hold office after 65. To say so will be reading one's own opinion into the decision of the justices. And I know that that is not the position that the Honorable Dominic Ayine himself is taking, that by this decision, people who are above 65 and are in public office can continue to hold office. That is not the case. They gave a clear distinction between what that is and then what we have as regards the public office simpliciter. And that distinction is what led them to come to the conclusion that his office was not one contemplated by the said Article 190, simpliciter.
Dr. Ayine.
Well, Evans, thank you very much. But I am wondering how my, colleague, Honorable Member of Parliament, and my predecessor in the Office of Deputy Attorney General came by the reasons given by the court. He said that the court has drawn distinctions. I was in court today. I listened to the judgment. No reasons were given. The CJ, that is Eninyebo CJ, basically said, by a 5-2 decision, and then he listed the members of the majority, and then the minority justices who dissented, and then said the writ of the plaintiff is hereby dismissed, and that we should go to the reasons we filed with the registry of the court, and that we should go to the registry of the court tomorrow for the judgment, whereupon we'll be able to know the reasons given. So I am at a loss as to where my brother is drawing the distinctions from, except to say that maybe he's anticipating that the justices adopted wholesale, maybe hook, line, and sinker, for want of a better expression, the arguments of the learned Attorney General. But I think the distinction that, the Honorable Kwemka is drawing is what, I read it in their pleadings, and I found it just, as an enterprise in sophistry, because you see
an enterprise in sophistry.
Yes, yeah, and Evans, I'm saying so because, see, a public officer is a product of the public office. There must first of all be a public office created legitimately in accordance with law before you can have a public officer who occupies that office. And so the public officer must draw, his legitimacy, his, legal legitimacy from the public office as created by law. All right. And my argument, let me say the argument that we put before the Supreme Court is that the Office of the Special Prosecutor draws its legislative DNA, all right, from the chapter of the Constitution on Public Services of Ghana. Because it was very clear, and I'm waiting to see how they dealt with the parliamentary debates that we put before them as evidence. Because we did put before them the parliamentary debates and how Parliament itself, made it abundantly clear through the chairman on constitutional legal, on the committee of the, Parliament on constitutional legal and parliamentary affairs, that the office of the special prosecutor was a creature of Article 190 of the Constitution. If that is the case, then it means that, the retirement age is stipulated under Article 199, 1, 2, Article 191(1), and then Article 199, 4 must apply to him. Okay, it must apply to that office because, as I said, its legislative DNA is taken from the chapter of the Constitution on the public services of Ghana. And so I'll be pleasantly surprised if the Supreme Court is in a position to draw a distinction that says that, okay, despite the fact that this office is a creature of the public services of Ghana, all right, its character is such that it is so specialized that it must be taken outside the framework of that chapter and be given a different constitutional or legislative treatment altogether. This will be really baffling. And an act of parliament, as the Honorable Deputy Attorney General himself knows, cannot run against the grain of the constitutional provisions. And so I wasn't taking a very narrow view of this matter. In fact, I did, the arguments we put forward showed quite clearly the legislative intent and purpose of the amendment in 1994, okay, of Article 199 in order to add Article 199(4) to provide for the extension of the retirement age to a maximum of 65. It was the Honorable Obeda Samoa, then Dr. Obeda Samoa, then Attorney General, who moved the motion for the second reading of the Constitution Amendment Act of 1994, which amended the Constitution in order to add Article 199, 4 to the Constitution, giving the public servants the possibility of obtaining post-retirement contracts of up to a maximum of 65 years. And I think that is where the worry of my senior brother Vitus Azay must be taken very seriously. Of course, I'm sure those of you who know Vitus have known him only as an anti-corruption crusader. But Vitus worked for many years, with the Internal Revenue, the then Internal Revenue Service, now Domestic Tax Division of the Ghana Revenue Authority. And so he knows what he's talking about when he's talking about the public services of Ghana. So that concern that he's raised is a very legitimate concern. If you have people who are aged 70 years of age or 80 years of age coming back to take key positions in the public services, whilst young people who have been working there for 15, 20, 30 years are still matching time as deputy directors and so on, whilst people are being brought back from retirement into those positions, it becomes very problematic. Of course, I do believe that the Deputy Attorney General when he says that the Supreme Court will probably not be giving us a generalized ruling that says that, people can retire and then come back. So whether you're a Forestry Commission Chief Executive, GMPC Chief Executive, and so on, you can be 80 years, 90 years, it doesn't matter. I believe that will be, very iconoclastic of the Supreme Court if it comes to that position, because then it will, very much, do damage to the public services as we know them in this country.
Mr. Kwenka-Job, from a layman's point of view, how is the Special Prosecutor's Office, no matter how specialized it is, not a public office, as in we pay, the public pay for that office to be set up? We created it, we fund it, we pay Martin Amidou. How is it not a public service and Martin Amidou not a public officer in the simplest of terms, as we've come to know those two terms? How do you make a distinction there
Once again, thank you.
But the network, I think there are breaks.
No, sorry, Ms. Azim, can you hear me? Can you hear me, Ms. Azim? This question.
Yes, I can hear you.
This question is actually to the Deputy Attorney General.
Was the question directed at me?
No, this is to the Deputy Attorney General. Mr. Kwenka,
thank you very much.
Okay.
Yeah. How do you know?
Again, let me say this, and I would like to say it very forcefully, that I have again heard the learned former Deputy Attorney General espouse his position. But he understands that when the justices say that your writ is dismissed by a 5-2 majority, it means that they did not agree with your arguments. He understands. You don't need to read the judgment to know that that is the meaning of a decision, that they disagreed with the position you took. That is why they say it is dismissed. If they had agreed with the position he took and the arguments he has canvassed even this evening, possibly, if they had agreed with that, they would have upheld the submissions and he would have been the victor today. But the justices of the Supreme Court, by a 5-2 majority, rejected the argument he's canvassing. Yes, he has indicated that they are saying that the registries will be contacted for copies of the judgment by tomorrow and etc. And that he didn't know where I got a decision to know that this is the situation. Again, I would like him to know that once his position was dismissed, it goes clearly that there was merit in our submission. That's why his position was dismissed. But to stretch the argument further, as I have indicated earlier, Evans, your question is very simple, that we established it with public funds, and it is an office occupied by a person from the, in public office and etc.
A person who must certainly be a public servant.
Yes, how could it then be distinguished from the other public offices as we have stated in our constitution, as the former Deputy Attorney General has stated in compliance with 191 and 194 and 199 as was amended. But let me indicate this very clearly, and I want to state this once more, that when we were sent and we had our discussions, we looked at the provisions as we are stated. We looked at the Act. And again, I heard Vitus Azim state that the Act, he has read it, and it doesn't state anywhere that a person can be more than 65 years and still occupy that office. Let me add that there is nowhere in the Act that equally states that a person 65 years or above cannot hold that office. There is equally no such provision in there. Otherwise, all that the plaintiffs in this matter would have said, we are going to refer to that portion of the law and simply come to the conclusion that that portion of the law says that a person who has this age or that will not be qualified. There is nothing of the sort. So it left us with a purposive interpretation of the provisions that were actually put before the learned justices of the Supreme Court. And they took their position upon a true and proper interpretation. They took a position that there was no merit in the plaintiff's case, and so dismissed it. As he has indicated, yes, we are of the opinion that our position has been upheld, and tomorrow, when the copies are made available, all of us will have the opportunity to read it, and perhaps could have another opportunity to discuss further whatever is found in there. But as he has said, the decision today was carried out. The plaintiff's case was dismissed. The details of it will come out tomorrow. And then the position I have canvassed this evening, you will find whether or not that is upheld or whatever decisions they took in arriving at the dismissal of the plaintiff's case will clearly be aggregated and stated without any shred of doubt.
Talking about
what I'm saying, and I have urged my elder brother to look at it carefully, Mr. Azim, is that we should not oversimplify the argument. And I repeat that by just saying that, look, from all indications, this decision is far-reaching and it endorses that public servants can be in office beyond 65 years. No, that has not been the argument of the Attorney General. We've not argued that anywhere, that they should hold that all other public office holders retire completely after 65. In fact, there's an earlier decision of the Supreme Court on this matter, and it actually complied strictly with the provisions of the Constitution and agreed with the fact that when you are 60, you retire, but government has an opportunity to contract your services up to a maximum of 5 years. Therefore, after 65 years, strictly speaking, you cannot hold public office anymore. So we went beyond that argument and tried.
And we've lost him there. We'll try and reconnect him. But I think I still have Mr. Okay, I think it's back.
This specialized office was specifically created as a special purpose vehicle to fight corruption. It's not one contemplated by the said provisions that he actually argued on. And to that extent, we were urging that they dismiss his writ, and same has been dismissed.
Let me bring in Ms. Azim. Ms. Azim, does that argument convince you?
No, I'm not convinced, because for one thing, there are two things. My network is not good, but there are two things that I just want to say. If there's no public office set up, there will be no public officer appointed to that office. Number two, if the office of special prosecutor was a specially carved office, with exemptions for age of whoever can occupy that position, it should have been clearly stated in the act that set up the office of special prosecutor. In that case, the Attorney General who took the bill to Parliament failed Ghanaians by not including that in the bill. Thirdly, tomorrow, the Attorney General can go to Supreme Court and say that, oh, the Executive Director of EOCO should be also treated the same way because it's a specialized office to handle corruption or white-collar jobs, white-collar crimes. Where would we go from there? Why is it not in the act that set Act 959 that set up the Office of Special Prosecutor? Can they explain that? Was it an oversight?
Joseph Penka, do you want to answer that question?
Yes, my answer will be very straight. And if you carefully listen to me in my earlier submission, I indicated to you that his argument that there was no such provision in the Office of the Special Prosecutor Act that stated that he can be in office even if he's beyond 65. That was not expressly stated. I asked the converse whether it was expressly stated in there that if you are 65 years, you cannot hold that. We read that and draw that from the Constitution, not so, as he has actually stated, and the plaintiff did state. That is drawn from the Constitution. And I have repeatedly said, time without number, this is...
What does the Constitution say? The Constitution says 65, you shouldn't.
I have no dispute about that. I think you have not...
We have challenges with the alliance there.
Sorry.
Okay, we could hear you now. Yes. Yes, go on.
With the position, public office, agree with that position. We have not disputed that. In fact, I have said before that after 65, you cannot hold public office. I have said it. I've said that you cannot hold public office.
But that's not the case with the Special Prosecutor's Office.
By the same Supreme Court. But I'm saying that our argument in this is that we went beyond that and forcefully argued that that office is not one.
Challenges with that line. I want to take a break. When I return, we'll explore that controversy, but also the further implications of so the president, then, any president can, by an act of parliament, set up a specialized institution and put anybody there, regardless of the person's age, whether the person has reached or far exceeded his retirement age or not. does that open a Pandora's box going forward for political exploitation of this particular verdict going forward? When Dr. Ayine and Co has argued that you can find equally competent young men to take up such important positions, create a situation where possibly you're going to be occupying some of these positions with people who are long past their, retirement ages and may be on the decline. We're going to be interrogating that implication when we return. Stay with us. And you're still live with me here on PM Express. My guest is still Deputy Attorney General Joseph Kpenka Diop. Also with me is former Deputy Attorney General Dr. Dominic Ayine and former head of the Ghana Integrity Initiative Anti-Corruption Campaigner Vitus Zim. Mr. Zim, just before we went for the break, we had a challenge with your line, but you made a very important point and asked a question which you got an answer, I hope, from Joseph Kpenka Diop. That answer, did it address the question you asked?
I didn't get the answer very well.
Okay, but let's interrogate this final implication of this, and something that I've heard.
Yes, I'm saying that. Yeah, the point I made was that tomorrow, even without the act, tomorrow the Attorney General can go to court and say that the Executive Director of EYOCO is heading a specialized agency that is supposed to investigate white-collar jobs, white-collar crimes. And so he should be allowed to stay beyond 65 years. Can we challenge it based on this judgment that has been made today?
Mr. Kpenka Diop, on that specific example Vitus Zim's side, he has a point, has he not? I think he's frozen there. But let me bring, I'm sure you can hear me. Let me bring back Dr. Dominic Ayine. Dr. Ayine, I've heard you make the point before when this first came up, that one of the implications of this is that any other president can create another specialized institution and put anybody there regardless of age. Your fear is that then leaves a door open for people to be placed in such positions who have way past their best, possibly because of age and whatever reason else is, because the president can, because of this ruling, and then crowds out the young minds who can really push and do this job in the system. You believe, how big a problem is that? Some say that is not a big deal. I've heard people say, but that is just one office out of many public offices, and so that argument doesn't really hold.
Evans, I don't think, we don't have the empirical evidence to be able to say with certainty how much of a problem it is in the public service, but there is, substantial or significant anecdotal evidence in the system, for us to be able to say that it is a worrying trend. And as my senior brother Vitus Zim has, indicated, it opens the door, or let me say, it creates a slippery slope for any president in future to create such offices and then bring retirees back into, a public service, or to even say that existing public services, we can amend the laws, establishing them, and then increase the ages so that the president can bring persons who are past the constitutional retirement age back into the public services of Ghana. I think that is very worrying. And the debate when this Article 199 was being amended, made it very clear that the constitutional commissions in their debate, in their proposals on the public services of Ghana, noted the fact that, older people were occupying positions for a very long time, and the trend was always, in the past, to swear an affidavit and then say that you have forgotten your date of birth, and because of that you were born in 1949 rather than 45, and reduce your age by 4 years and remain in the service. So you occupy this position for a very long time. Younger people cannot get promotion, and then even the establishment, all right, the establishment quotas of public service institutions can sometimes get choked because there are people at the top who are refusing to retire, and so maybe we need the Public Services Commission to come in and give us the empirical data on what is happening in the public services when it comes to post-retirement contracts. But it's a very naughty public policy issue that we need to address, as a country.
Mr. Zim, I've heard others argue that sometimes we are too quick. I think we lost your sound there. We are too quick to let people who just turned 65 go just because of this law on our books. That sometimes people are still very, very active and brilliant, even way past 66, and that we shouldn't be too quick to sort of ease them out when they can actually do the job. Hello, Mr. Zim, can you hear me? Yes.
Can I come in?
Yes, please.
It's not even an issue whether we are depriving other people of jobs or not. The fact is that there is a law, and we are in a democracy. The Constitution tells us what we should do. So there should be no reason why we should go outside the Constitution and do things.
Isn't that why we need this ruling, to vary that, to allow people who are 66 and above who are still qualified to do the job?
The Constitution framers knew that you can be at 70 and still work. You can be at 80 and still work. But they found it necessary to peg it at a certain age. So if we believe in that argument, then we should go back and amend the Constitution. Otherwise, we are not doing what is right.
Well, very interesting. Some may argue that, in fact, this ruling effectively amends that particular part of the Constitution for specialized agencies, such as the Special Prosecutor's Office. And I'm grateful, gentlemen. I'm sure tomorrow when we get to see the full reasoning behind the verdict, we will return to talk about the public policy implications as we have elaborated on the show. We don't have Joseph Pandora because I see his can you hear me?
I'm here.
Okay.
Yes, I can hear you.
Give me. I have 60 seconds to wrap up. Give me your final thoughts on this, in terms of the implications.
Very clearly, the rules of interpretation that the Supreme Court leans on now is what we call the purposive interpretation. So they interpret it to suit the purpose rather than just the letter. So the literalist approach to interpretation has been abandoned by the Supreme Court long ago. So they went ahead of that and looked at the spirit and the letter together, and then they gave a purposive interpretation, and therefore did not agree with the position advocated by my elder brother, the Honorable Dominic.
You disagree? This is a yes or no?
Why not let us wait? Tomorrow we will all read the judgment in more detail, and then we can have further discussion on this.
But you quickly, yes or no? You disagree with the wide implications of this on public policy going forward? Do you disagree with that? Okay, you can't seem to hear me, but that's it for tonight. We'll wait to see the details in the judgment when it comes tomorrow. Thank you very much for staying with us. My name is Evan Smith. Enjoy the rest of the evening.